I don't want to understate the importance of the finding that Harvard and UNC violated the 14th Amendment. That means the court found that they engaged in racial discrimination. They discriminated against Asians. Full stop.
This is Manhattan Insights, a Manhattan Institute production. Ilya, I understand your manuscript is all done. Congratulations.
Thanks. It's a good feeling. You've written books. You know how it is. It's exhausting, and it's kind of don't know what to do with myself right now, other than take care of my baby twins at home. So it's a nice grounding.
But of course, Ilya, you have been very busy, not just writing this book, which I'm sure is going to be a very influential and important one, but also covering what has been a really momentous Supreme Court term. I'm curious. I mean, you've been following the Supreme Court closely for a very long time now. And I wonder, when you think in the kind of grand scheme of things, how consequential has this term been relative to others, or how consequential do you expect it to be when we look back?
Yeah, this goes to my last book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. As you said in your intro, these issues of legitimacy that keep cropping up, although it's kind of a Streisand effect. The people who are complaining about the court's legitimacy are doing the most to damage it, as it were. But this term and last term, I think, are hugely consequential. Last term, of course, the overturning of Roe v. Wade, a few other big decisions. This term, the overturning of racial preferences in higher admissions, checking executive overreach, continuing big First Amendment and property rights cases that we'll get into. Really what the court is doing is clearing away a lot of, not the Warren Court from the 60s, kind of what's thought of as liberal judicial activism, but the hand-waving 1970s Warren Burger Court. A lot of 1970s precedents are being questioned and sometimes explicitly overturned, sometimes just implicitly. And that era was known for not giving clear standards, but kind of the court having a broad kind of social justice orientation.
Fascinating. And I imagine it's going to take a very long time for us to see how the larger American scene, how policymakers, how cultural institutions respond to these new decisions. But
right, and I hasten to add, this doesn't mean that this is some sort of conservative counter-revolution. In fact, this term especially, there's a big contrast between the last two terms. This term, half the cases were unanimous, and only 5 of the 58 decisions consisted of the 6 Republican-appointed justices in the majority versus the 3 Democratic-appointed justices in dissent. And in fact, until the last 2 days of the term, when we had Students for Fair Admission, the affirmative action case, 303 Creative, the website designer for same-sex marriage, and the student loan case, until those last 2 days, the narrative was, well, this court is unpredictable and all over the place, and conservatives lost on election cases, and then this unusual alignment in the Indian law case, and all these other things going on. And the last 2 days of the term don't change that overall analysis. The statistics belie the vibe, as the kids might put it. The court still does come out in areas where conservatives or those on the center right might like in most of the politically salient cases. But overall, it's a very thoughtful court. And for example, Justices Thomas and Alito, you'd think if this was a right-wing court, they would be in the assent. They were least in the majority. And there was at least one liberal member of the court in the majority, I think in 79% of divided cases. So it's a little more complicated than Joe Biden saying it's an abnormal court. Most of those controversial decisions have the support of the American people. So if it's abnormal, then I guess the general median voter is abnormal.
We're going to get into some specific cases, Ilya, but because you are arguably the nation's premier Supreme Court watcher, I am curious how you think about the alignments on the court. There is this cliche now that whereas in the past you always had a swing justice, you now don't have a swing justice, and this represents some dramatic break with the past. But I suppose one way of looking at the court now is that there are multiple swing justices depending on the issue at stake. Can you talk to us about what you see as the emerging cleavages, both in the court as a whole, but also within the kind of so-called conservative majority?
I think that's exactly right. We had gotten used to kind of 3 or 4 on the left, 3 or 4 on the right, and 1 or 2 human jump balls in the middle. Most recently, Justice Kennedy, of course. Before that, Justice O'Connor, Justice Powell. There were others for about 40 years or so. But that's the anomaly. When you look historically, it's rarely been balanced in that way, regardless of the party of the president nominating the justices or what their supposed political balance might be. What we have, some people have called it a 3-3-3 court with Thomas Alito and Gorsuch on the right and Sotomayor, Kagan, and now Jackson on the left, and the chief plus Kavanaugh and Barrett in the middle. But that's overly simplified as well. It's rare that the issues so neatly align to have those breaks. Kavanaugh's most in the majority. He's the man in the middle, the median vote, as it were, but not a swing vote. And you don't think about it as the Kavanaugh court like we thought about the Kennedy court controlling any particular case. You have heterodox alignments in criminal law, for example. Gorsuch is together with Sotomayor in revamping, in a very originalist way, I should say, conceptions of the Fourth Amendment or the Confrontation Clause under the Sixth Amendment, things like this. On certain issues, you have the coalition of the, either call it the centrists or the pragmatists versus call it the principled or what have you, the kind of the left and the right against the middle. There are different dynamics in different areas of law. And like I just said, only in 5 cases this term did we have the 6 so-called conservatives versus the 3 so-called liberals. And that's, we're going to see a lot of change and redirection of the jurisprudence in what, to my mind, is a common sense originalism, not a common good, to check the debate on the right in many circles. But this is a court where you just take it at face value and read the opinions that I think they're all working hard to get it right.
In Students for Fair Admissions, Justice Roberts stated that universities may consider an applicant's discussion of how race affected his or her life, but that they may not simply establish through application essays or other means the regime we hold unlawful today. Talk to us about that. I mean, some see a loophole where essentially the Chief Justice has said, hey, actually you can in fact take race into account. Others don't see a loophole. They believe that actually this is a very kind of narrow path for folks who want to use race-conscious admissions. I'm curious how you see this playing out.
Well, this is why Reno Mukherjee and I called it the end of the beginning of the battle for colorblind equal opportunity in education. There is going to obviously be litigation over different things that different institutions do now to try to maintain their commitments to diversity or at least racial diversity. But Roberts' line is clear. You can't simply use something else, call it these adversity statements, not diversity, but adversity statements, overcoming things, which are good things to take into account. If someone, is from an underprivileged background and they've succeeded, perhaps their parents have not paid for them to, go start a nonprofit and spend the summer, doing whatever abroad and kind of coaching their application. But they hopefully still have taken standardized tests, the great equalizer. That's why it's kind of an ironic shame that schools are getting rid of those as well in the name of equity. It's kind of counterproductive in that regard. But in any event, we'll see what schools do, and that will certainly be, those 2 lines that you read from the majority is going to be the fertile battleground for litigation.
The court found UNC and Harvard's admissions policies to violate the 14th Amendment, but Justice Gorsuch wrote that they also violate the plain text of the 1964 Civil Rights Act. Might we see the Civil Rights Act wielded against racial preferences in a future case? And I wonder if you could talk us through the subtleties of the difference here. Because, I think that the headline is simply that, race-conscious admissions were overturned. But it seems as though whether or not that's done on a constitutional basis or a statutory basis could matter quite a lot.
Yeah, I don't want to understate the importance of the finding that Harvard and UNC violated the 14th Amendment. That means the court found that they engaged in racial discrimination. They discriminated against Asians, full stop. And they didn't have a good enough reason. They said, trust us was their reason. And Roberts said, we can't evaluate that. You have no endpoint. You have no measure of when these race-conscious racial preferences can stop. That's a big deal. Now, The difference between the constitutional analysis, the 14th Amendment, and the Title VI statutory analysis, the reason it came in at all is because, of course, Harvard is not a state school. And so, why does the Constitution apply to private schools in the first place? And the answer is through federal funding. When schools accept federal funding, there's all sorts of strings attached, which range from observing accounting standards, so the money's not ill spent, to non-discrimination principles. And that's obviously what's at issue here. In fact, some of the work that I've been doing elsewhere has urged Congress to tie First Amendment protections, speech protections, conscience protections to those federal funds as well to combat some of the illiberal trends on campus. But in any event, the Title VI language, the Civil Rights Act language, if anything, is even stronger in preventing racial preferences than constitutional analysis might be. And so that's an important point that Gorsuch is making, both for purposes of applying directly to Harvard and other selective private institutions, but also, as you say, for future litigation that I think will invoke the Civil Rights Act as much or more as the Constitution.
So you see that becoming an issue that will persist. You'll see more litigation on this question.
Absolutely, and I see more congressional action as well as Congress tries, and sometimes, depending on the political, the partisan breakdown, perhaps adding those sorts of strings onto federal funds.
There's a case making its way through the courts about Thomas Jefferson High School for Science and Technology, a selective Virginia public high school that it appears was aiming to engineer a less heavily Asian student body, and then the authorities adjusted its admissions policies to that end. Do you expect to see more cases along these lines, challenging policies like these as fundamentally grounded in discrimination?
So that's an example of a facially racially neutral policy. That is, they didn't say we're going to rebalance or put a thumb on the scales for certain races and downgrade others. They said we're going to not use the admissions test for as many. We're not going to use middle school GPAs and these other characteristics. Instead, they produced a formula about different schools in Fairfax, different feeder schools in Fairfax County and other things that allowed them to achieve a lot of the racial balancing they were seeking. This, to me, seems like just one of those workarounds that John Roberts, in his majority opinion, was looking to prevent. So the cert petition is going to go in this case. The Fourth Circuit just approved what Fairfax School Board did. I think their ruling just came down about a month ago. There's going to be a cert petition. I imagine the court is not going to want to look at it so quickly again. So I think they'll probably vacate the Fourth Circuit decision and tell them to redo it in light of Students for Fair Admission. And then a year or two down the road, the court might start taking up these follow-on cases. But this is definitely one to watch. And the opinions in the Fourth Circuit, I think, do lay out pretty well both sides' positions. The dissent there was by my law school classmate Jay Richardson, so I'm particularly I was delighted to see that. I think it's a strong piece that, if and when this gets to the court, will likely be adopted.
It seems very fraught when you have race-neutral alternatives, but the intention behind them is what's at issue. I wonder how straightforward it will be to resolve some of these cases. Not
straightforward at all. This is going to be heavily fact-specific, heavily discovery-specific. Litigators looking at trying to find smoking guns, statements, emails. What motivation is important because just like the reaction to Brown v. Board, where desegregation did not happen overnight just because of that one Supreme Court ruling, and a lot of school districts engaged in massive resistance by shutting down certain facilities. There were certain things as well with public facilities, with parks and pools and things that were spun off and closed and privatized and things like that. So race neutral, all of these positions were, but the effect was clear, and there was witness testimony to that effect in the eventual litigation as well. I think there's going to be somewhat of a similar dynamic here, not with presumably bigoted statements about Asians, although maybe some of that along the lines of Harvard's downgrading the personalities of Asian American applicants and things like that, but more just, what can we do? What if we tweak this metric? What'll our racial balance be then? That sort of kind of a technocratic social engineering, which the Supreme Court's opinion, I think, is firmly against. But a lot of lawyers are going to have to sift through a lot of documents to get at that in any particular case.
Does it make any difference that Virginia now has a conservative governor who I imagine is sympathetic to Asian American parents in Northern Virginia who are concerned about the changing admission standards? Or is this a case where it is the county government that has wide autonomy in the policies that it's advancing regarding the racial composition of students at TJ?
Well, the governor or the governor's secretary of education, which is an appointed position in the governor's cabinet, can't unilaterally change or trump local school boards. Now, the attorney general, who is elected independently, and you could have the governor and attorney general of different parties, they're currently both Republican in Virginia, has investigative resources to enforce whether it be Supreme Court rulings or Virginia statutes or what have you. And I know for a fact the Virginia AG's office is looking at not TJ in this case, but what schools are going to be doing, what universities are going to be doing in light of their admissions, because that's certainly part of their oversight tools to make sure that they're complying with the law.
Interesting. So if these cases wind up back with the Fourth Circuit, basically the ideological sensibilities of the AG's office could have some bearing on how those cases unfold?
Certainly the views of the state government or of the attorney general of the state where the school board is doing the challenged activities are going to be important. And if the AG produces a report, again, the issues are slightly different in K-12 than in higher ed, but if they produce a report that say, Virginia Tech is doing the same sort of policy as the Fairfax School Board is here, and we find that contradicts Students for Fair Admissions, that's going to be persuasive that what the school board is doing is violates the Supreme Court ruling as well.
Ilya, you have emerged as an incredibly visible and energetic champion of the freedom of speech and freedom of conscience. There was a big, important Supreme Court case bearing on these questions, 303 Creative LLC versus Elenis, which held that the First Amendment prohibits Colorado from forcing a website designer to create expressive designs, advancing messages with which the designer disagrees. Ilya, can you explain to us the basic facts of the 303 Creative case?
So you'll recall the Masterpiece Cake Shop case 5 years ago where the baker in Colorado was being prosecuted by the Civil Rights Commission for declining to make a cake for a same-sex wedding. There, part of the debate was whether cake baking was an expressive activity and therefore whether he had any free speech rights to assert in the first place. Well, here, that question is off the table. That is, this is a graphic designer who wants to start creating websites for weddings, but fears that she will be sued under the same law that Masterpiece Cake Shop was ensnared in. And so she launched what's known as a pre-enforcement challenge. In the First Amendment, you don't have to wait till someone censors you or fines you or throws you in jail. If your speech is being chilled and you want to make that First Amendment claim, you can just go ahead in court and claim it. And that's what she did. There was some bad reporting about whether she had standing because did someone ask her to make a website or not? That's irrelevant. As has been for decades, she made this what's called a pre-enforcement challenge. And she said, look, I'm willing to serve anybody. And indeed, that's a stipulation by both parties. She has and will have gay clients who want to do launch a business or celebrate a birthday or whatever her services are for. But she will not advance any message, whether it be celebrating same-sex marriage or other things that she doesn't like. And can the state nevertheless compel her to do so under its anti-discrimination law?
Is this properly understood as a free speech case or a non-discrimination case? And give us some of the details on the case if you could.
It's purely a speech case. I thought you were going to say, is it a speech case? Is it religion? It's not religion at all. To be clear, this is about compelling a message. It has nothing to do with the reason why the speaker objects to the message, whether that's a religious, secular objection or anything else. It does not focus on the status of either the speaker or the person who wants to contract for the speaker's services. It's purely about the message. And so it's been very frustrating to see reported in the media commented on legal blogs by smart scholars who know better, that this is a license to discriminate in some ways. And now, every limo driver or hotel is going to say, well, we don't want to express the message of supporting same-sex wedding, and so we're not going to do that. That's not what the court said. The court said that graphic design is inherently an expressive activity. In fact, it's not just that the court said that; the parties stipulated to that. The court also found, again, this is another stipulation. It's like pounding my head against the desk when I see this reporting, because the parties all agreed. Colorado agreed that Lori Smith, the owner, the graphic designer, the owner of 303 Creative, has clients, is willing to serve the LGBT community if they have a business to run or a birthday party they want to throw or what have you. But she's not going to celebrate messages, not just about same-sex marriage or not something that's related to the Bible, but she doesn't want to glorify violence, for example. There's other things that she just objects to for whatever reason. And this is an important ruling that protects everyone, whether it's a gay atheist website designer who doesn't want to create a website for who knows, some Christian group or a legal group or the Manhattan Institute because of the brief that we filed in this case. That is their right as well. And I was proud to have filed this brief for us alongside Eugene Volokh and Dale Carpenter, both of whom are both advocates for gay rights and for the freedom of speech. We actually found ourselves on opposite sides in Masterpiece Cake Shop. 303 Creative completed the work that Masterpiece Cake Shop didn't get to, the baker that was being forced to create a cake for a same-sex wedding. There, the argument was over whether cake baking was sufficiently expressive to be protected by the free speech clause. There will be litigation over, someone claims that they're actually an expressive activity, or you're a Subway sandwich artist. Is that expressive? Well, the real answer is no, unless your sandwich is in the form of a swastika or a pride flag or something like that. So there are going to be edge cases of that line, but it's pretty clear that this is about expressing and not being compelled to state a particular message, regardless of what the political atmospherics might be around. And it protects anyone of any ideology, religious faith, or no faith. And I should add, Reihan, that I'm proud to be one of just 3 lawyers in the entire country to have filed briefs supporting both Jim Obergefell in the marriage cases and Jack Phillips in Masterpiece, and now Lori Smith in 303 Creative. That seems to me like a very clear delineation between state action and the government having to treat everyone equally, and private action where we have individual rights of speech and conscience and otherwise.
You're also an articulate proponent of economic liberty and the argument that the courts should take property rights seriously. There were a number of important and consequential property rights cases before the Supreme Court this past term. I wonder if you could talk to us about that.
Yeah. So the first one was, they were both unanimous, at least largely. The first one involved what's called home equity theft. That is this phenomenon where someone owes some back taxes or other fees to the municipal or state government on their home. The home is seized and sold in a tax sale. And, what happens to the remainder? Let's say you owe $10,000, your home sells for $100,000. What happens to that $90,000? Well, until this case, in 14 states, the state or municipal government would simply take that money. You wouldn't get it back. And so that's why this has become called home equity theft. The court ruled unanimously that that's not appropriate, that you're taking property without any justification or just compensation. Probably an excessive fine as well, violating the Eighth Amendment. The court didn't reach that, but that's an important issue for when local governments go out of control in lots of ways in seizing people's property.
I'm curious about the arguments on both sides. Just given that it was unanimously decided, I'm curious about the argument against the ruling. What were the contours of it? That
this is a decision by the state that when you owe this and you force the state to have this burden of sending sheriffs and having an auction and doing all the administrative stuff, you simply forfeit your right to the property. You haven't paid this money. You had proper notice. You had due process, and you still failed. And so the you forfeited that property or your interest in it. That's the argument. It doesn't sound very strong, but that's, I guess, why the Supreme Court ultimately ruled unanimously.
Fascinating.
The other property rights case is called Sackett versus EPA. The Sacketts in Idaho wanted to build a home on land that was near but not touching water, and the EPA blocked them. If that sounds vaguely familiar, it's because a decade ago they won another unanimous Supreme Court ruling that they could challenge the EPA before it started assessing $75,000 daily fines against them. You could have your day in court right away. And here, on the merits, the court ruled that the Sackett's home wasn't subject to federal jurisdiction because it was, again, near but not on navigable waters that went interstate, something akin to oceans, lakes, rivers, and streams. Adjacent wetlands that are indistinguishable from these bodies of water can be regulated, can have the federal government come in, but not just something that's near to or what have you. The court was unanimous in ruling for the Sacketts. They split 6-3 on the standards to apply.
I'm curious, what do you see as the longer-term implications of the Sackett decision? Is this something that could have a meaningful effect on the workings of the regulatory state?
I think just like last term in West Virginia versus EPA, which was a Clean Air Act decision and slapping down EPA jurisdiction to make laws without Congress having previously spoken, here under the Clean Water Act, similarly, Congress could try to assert greater jurisdiction, but they haven't, and so this provides clarity that as with most property law, this should be a local and state decision in terms of how to regulate things, and the federal government comes in indeed when there's interstate commerce or streams that flow interstate, things like that. So I think it provides a lot of certainty and shores up the value of property that, whether it's developed for your dream home or higher uses for commercial reasons or what have you.
There is a perception that you addressed earlier on that with this 6-3 majority of Republican appointees, of conservative justices, that the Roberts Court is tilting in one particular very strong direction. Yet there were a couple of voting rights cases that seemed to challenge that perception. I wonder if you could talk to us about some of the recent voting rights jurisprudence and the lessons we can take away from it.
Yeah, those are probably the biggest counterexamples to this narrative that it's a right-wing court. I gave you some statistics earlier on, but just in terms of important cases, that happens as well. In Allen versus Milligan, the court 5-4 maintained the block on the Alabama's congressional map that was redistricted after the last census, basically having a Goldilocks standard of how to use race. Not too little, not too much, to maintain the ability of racial minorities, in this case African Americans, to elect their candidates of choice. Since then, already the Alabama legislature has enacted a new map, and it hasn't quite created the two minority-majority districts that observers thought the Supreme Court was requiring it to, but it did increase the percentage of black voters in the second district where they're not a minority. We'll see if that survives. But the court did not
you expect more litigation then?
Oh, there is. I think it's already been sued.
Already, yeah.
Yeah. Of course, it's voting rights is after redistricting law is a lawyer full employment act, to be sure, every decade.
And by the way, just to be clear, that decision could have major consequences for political outcomes. I mean, some have argued that this decision alone would...
When you talk about labeling this court as specifically favoring Republican interests, this is the case that most directly implicates partisan politics with not just Alabama, but redistricting in North Carolina, Texas, Louisiana, a couple of other states. This ruling could net the Democrats 5-6 seats, which is the margin in the House right now.
I wonder what you think about that case on the merits, because I will say that there are a number of, call them legal conservatives, who have strenuously objected to the decision. And there are also just, even leaving aside the kind of constitutional question, there is this view that having districts in which minority voters are not necessarily a majority, but a substantial constituency, could actually represent a significant power on the part of minority voters. And also, increasingly over the last 20 years, you've seen more and more districts that are electing people of color to Congress, despite the fact that they're majority white constituencies. So I'm kind of curious about how you think about the kind of substance of the decision and what you think the Constitution mandates.
Yeah, what most frustrates me about this case, and for that matter, the other election law case that the so-called conservative position lost out on, Moore versus Harper, which I'll get to in a moment, is that the court did not really lay out a standard. In the Alabama case, it reiterated that the Constitution the Voting Rights Act does not require racial proportionality. You have 25% African American in your state. That means a quarter of your representatives have to be African American. That doesn't require that. But then what is what's good enough? And it relied on this 1986 decision in the Jingles case, which is kind of a balancing test and hard to apply. So again, a lawyer Full Employment Act. Again, I think there's a way for Alabama to lose here that's kind of more principled than what the court ultimately came up with. And this other case is similar in from that global perspective. Moore v. Harper, the North Carolina Supreme Court blocked a congressional redistricting plan based on a vague provision in the state constitution that all elections shall be free. And it said that this was too gerrymandered. Kind of hard to apply that standard, but regardless, it was a state court decision. The argument from the challengers was the election law clause gives the power over election regulation to state legislatures without the participation of state courts at all. And the court here, I think, correctly said, well, that's a bridge too far. Like other areas of law that are left to state jurisdiction, whether it be tort law, criminal law, family law, we still have judicial review. But sometime that judicial review could go too far. And indeed, the court said here, this is a 6-3 decision with Thomas Alito and Gorsuch dissenting. John Roberts wrote the majority, as he did in the Voting Rights Act, the Alabama case. It basically said that the decisions of legislatures remain subject to the ordinary exercise of state judicial review. What is the ordinary exercise of state judicial review? It beats me, but basically you now get a federal court backstop to the state court potentially going on a frolic and detour. We're really not better off than we were before, other than that this kind of wholesale idea that state legislative decisions are completely unreviewable, that's thrown out, which is understandable. But then what is the new standard? We don't know. Again, that's going to be litigated. And it's unfortunate because we have had examples of state Supreme Courts changing the law on the fly, throwing things out. This happened in Pennsylvania in the last election with respect to the counting of late arriving ballots that aren't signed properly and things like this. So I do think that this isn't an issue that's going to go away, and the court is going to have to step in, hopefully not to resolve the results of a presidential election. Hopefully it can have a technocratic opportunity to clean it up.
When you think about the lack of a clear standard in this instance, is that a reflection of the diversity of views and opinions among the justices? It's kind of like a least common denominator. Let's try to cobble together some workable majority, even if it means that we're introducing a ton of uncertainty for lower courts? Or do you think that there's almost a principled view that we want to have very narrow decisions, even if that means there's going to be a lack of certainty and clarity?
I think that Roberts and Kavanaugh, who are the Republican appointees that join the liberals on this, think that these are fact-specific cases, so it's hard to establish a standard more broad than just ordinary principles of judicial review. I think that's what's going on here.
Another very big case concerned the separation of powers and the federal student loan program. Biden versus Nebraska found that the administration had twisted the language of a 2003 statute, the HEROES Act, to unilaterally cancel student loans, which it did not have the authority to do. Talk to us about the implications of the case.
So this was about executive power. It was not a ruling that if Congress wiped away debt, that would be unconstitutional. There's an argument to be made under the Contracts Clause and otherwise, but that's not this case. Here, the court found this is one of those so-called ideological or partisan splits, but it found 6-3 that the power to modify or waive certain loan terms is not the power to wipe out debt altogether. And the only real question in this case, when they took it, was whether anybody would have standing to challenge it. That's a whole other kind of minefield of the court's standing doctrine. But here there's a Missouri agency that administers loans and loses out on revenues from administering fewer loans, and so the court found they had standing. Once they found that, it was clear that the administration was going to lose on the merits. For that matter, the majority opinion, also by John Roberts, he took for himself a lot of these big cases to decide. I think that was strategic in his mind. But he quotes Roberts in his majority opinion, Nancy Pelosi, who said that the president can't do it by himself. I don't think the president's lawyers thought that he could. I think they did it cynically ahead of the 2022 midterms. And this is not surprising given that the court threw out the CDC's eviction moratorium, OSHA's private vaccine mandate, and the EPA's Clean Power Plan regulations. Again, all things that were done by the respective agencies or executive orders without explicit grant of power by Congress.
Are you surprised that this case broke down along ideological lines? That is, would you have expected, say, Justice Kagan to have ruled with a majority, or is this something that's pretty par for the course?
Probably my biggest disappointment of the entire term was that Justice Kagan did not join the majority in this case. In fact, she ended up writing the dissent. It's frustrating that even in such a clear-cut abuse of executive power, the justices on the left seem to find no limits to, in this case, not just not federal power but executive power. I don't know if they would do the same thing if this was something that Donald Trump had been trying to do.
The Supreme Court has been using the major questions doctrine to circumscribe executive power, which Justice Roberts calls an identifiable body of law that has developed over a series of significant cases, all addressing a particular and recurring problem: agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted. The West Virginia versus EPA case last year was another example. What is the major questions doctrine as you understand it? Why does it matter? Justice Kagan attacks it for having no basis in Constitution or statute, and I gather you think she's wrong.
Right. The major questions doctrine arose out of what Justice Gorsuch has called hydraulic forces. Certain constitutional provisions or doctrines aren't enforced for a long time, and others arise to do the same work. So, for example, in the 14th Amendment, the Privileges or Immunities Clause was eviscerated by the slaughterhouse cases 5 years after the 14th Amendment was enacted. And so there were, for a long time, for decades, there were no substantive protections for rights against state violation, even though that was the whole purpose of the 14th Amendment. And so we had piecemeal arising substantive due process. So substantive rights are protected through the Due Process Clause. Similarly here, the non-delegation doctrine, the idea that each of the branches can't delegate, most notably Congress, can't give the legislative power to the executive. It can't say, pass the Truth, Beauty, and Goodness Act of 2023, giving the power of all of the cabinet secretaries to legislate whatever they think is best. You can't do that. Well, that kind of analysis has not been used, allowing Congress to pass the buck by enacting very broad legislation that then gets fleshed out by the agencies. And when people are upset, the congressman can say, no, I voted for truth, goodness, and beauty. It's that deputy undersecretary of such and such that harmed you. Go sue them. And so we get all these suits, and that's why in part the Supreme Court decides half a dozen of the biggest political questions in the country every June. And so the major questions doctrine arose so that the court could grapple with issues simply by saying this is a major question of either money or social regulation. And so we're not just going to defer or assume that the agency has the power to do this unless Congress has very clearly and explicitly given it that power. Justice Barrett, in her concurrence in Biden versus Nebraska, which is going to be studied for a long, long time, I think this is now the definitive statement on the major questions doctrine, talks about how it's a tool of statutory construction, very much in line with how then Judge Kavanaugh treated issues of administrative law, so as not to find statutory ambiguity that would lead to judges deferring to agencies. That theme of judicial deference to agency action to the executive is one that's been growing in the Roberts Court, and next term we're going to have several significant cases along those lines.
Talk to us about what we should be anticipating for the 2024 term. There appear to be a number of big administrative law cases concerning the non-delegation doctrine and this larger question of whether courts should defer to agencies. So I'm curious about the cases that you're keeping a close eye on.
So far, there aren't big culture war cases, as it were, like we've seen with abortion and affirmative action and the same-sex wedding website and things like this. But there are monumental administrative law cases, that is, the separation of powers between the branches and what kind of authority agencies have and how much courts should defer to their decision-making. The biggest case that we just filed in last week is called Loper Bright versus Raimondo. If you remember the Oscar-winning movie Coda, one of the minor plot points in that movie, it's about a largely deaf family that works in a small business. They have fishing boats. But one of the things that grinds their gears is they have to not only host a federal fisheries monitor on their boats to make sure that they're not catching undersized fish and otherwise violating regulations, but have to pay the salary for that monitor. Now, why do they do that? Is this a bad law that Congress passed, and we can talk about we should repeal this? Well, no. It's again this power that in this case the Commerce Department, specifically NOAA, the National Oceanic and Atmospheric Administration, has assumed to create this kind of self-funding mechanism, even though Congress hasn't appropriated funds in that regard. In this case, the court could have decided to take up an issue of interpretation of this fishing regulation or the broader legislation, but instead it took up the question of whether to overrule Chevron. Chevron is a case from 1984 that says that unless agencies are arbitrary and capricious, unless they're going completely crazy, courts defer to their interpretation of their operative statutes. And it's rebalanced over the years, I'd say unbalanced power in this country going towards administrative agencies. I don't know whether the court is going to take that big step in overruling Chevron altogether, but I think there's definitely going to be a paring back. So just like a few years ago in a case called Kaiser, the court completely changed the standard for when judges should defer to agencies that reinterpret their own regulations. That was the Auer case. The joke was they changed Auer, spelled A-U-E-R. They changed Auer deference to minute deference because it was much more limited now. Similarly, they're going to do something like that to Chevron. But I love the brief that we filed. My legal intern, Austin Severance, and our new legal fellow, Tim Rosenberger, who was the head of the Stanford Federal Society chapter that had that national newsmaking imbroglio over the shutdown of Judge Kyle Duncan. They did all the legwork on this brief, and I'm delighted how it turned out, fish puns and all.
So I'm curious, Ilya, if there really is a series of administrative law decisions that kind of rein in this, this practice, when it comes to administrative agencies arrogating to themselves powers that were not expressly stipulated in legislation. How do you think that's going to shape American political economy? how Congress does its work. I suppose one line of argument is that, look, you are baking in that we are going to have a more restrained and limited government. Another view is that, look, I mean, Congress is, may well pass things that further expand the size and scope of government, but they're just going to have to be more careful about how they do it, and they're going to have to be more explicit about how they do it. I'm curious about how you see that playing out.
Yeah, it's about accountability. It's about Congress. If you want to do something, then you have to do it. You can't just pass the buck. In theory, deference doctrines shouldn't have any sort of ideological or political valence because, of course, agencies can put in regulations that conservatives like or that progressives like. And the presidential administrations obviously go both to the left and the right. Chevron itself came out of conservative frustrations with the left-leaning D.C. circuit that was thwarting President Reagan's deregulatory agenda. And so the Supreme Court said, no, you should defer more to the agency, the political appointees in the agency that were elected. The president's administration was elected to go a different way, again, unless they're being crazy. And now the shoe is on the other foot, it seems, maybe because of certain structural public choice analyses. The deep state of the agencies is always going to lean left at this point. And so on balance, cutting down deference to agencies is something that more conservatives would like. That's probably so, but we'll see how whatever the new standards the court writes, how that ends up working in practice, and whether it will have, in states that have changed that at the state level. Some states have had significant difference, some have not. So it really depends on the type of cases that are brought and how aggressive the agencies are in promulgating the new types of regulations. Because another dynamic that we've seen in the last 10, 15 years is that the executive branch has gotten really aggressive with this pen and phone and tweet governance. It's not the Supreme Court reaching out to pare back the administrative state because it doesn't like it, but the more that this kind of executive action and regulation intrudes on civil society and people's whether personal or commercial abilities to plan their affairs, the more we get these legal challenges.
I wanted to raise two related lines of argument on administrative law. One is this classic argument that deference to agencies is inevitable in a complex society because you want to cede authority to sophisticated technocrats who understand the nuances of the issue, whereas when you're looking at lawmakers, they don't have the sophistication required to look at issues that arise on a case-by-case basis. Related to that is this argument that basically Congress doesn't have the resources. So, you have the Congressional Budget Office that's there to provide some additional capacity for lawmakers to understand some of the fiscal issues that might arise. So one line of argument is that, look, if you're going to hand lawmakers more authority, what you need is to help build up their capacity. Let's create a Congressional Regulatory Office if we have something in place like the REINS Act, which says that lawmakers need to actually vote on the most consequential regulations. I'm curious what you think about both of those lines of argument.
Well, I agree that it would be helpful to have a congressional OIRA, regulatory office that deals with these things. For that matter, you could have more subcommittees on detail to flesh out big pieces of legislation. After all, if the court keeps throwing the ball back into Congress's court, Congress is going to have to do something about it rather than pass the buck as it has. Now, the point about expertise is valid, but let's think about what expertise means. Agencies, if they're acting as biologists or economists, is one thing. If they're acting as lawyers and policymakers, it's quite something else. Congressmen, let alone judges, don't have the expertise to know perhaps what the best highest allowable level of mercury in your water might be. Maybe you can defer to the scientists at the EPA about that. But determining that we're going to regulate fixed power plants in one way rather than another, that seems like a policy-making decision rather than something that a scientist would be best positioned or an economist to do. So that's some of what the court has been doing in that Kaiser case that I mentioned, and I think that's a reasonable way of delineating the distinction between executive enforcement action and legislative lawmaking capability. And at the end of the day, Those of us who think Congress is, the federal government is doing too much in the first place, should give room for pause if Congress really doesn't have the capacity to do some sort of new, intricate, large-scale law. Well, maybe that's a reason not to contemplate it in the first place.
I'm curious. You're also someone who thinks deeply about policy and the policymaking process. It's natural that conservatives in Congress will be skeptical of the idea of beefing up the capacity of their own offices. There's a big trend towards sleeping in your office and returning some of your office budget back to the federal government. But I wonder, would you recommend that conservatives in Congress say, well, no, actually, we really do need a congressional OIRA, as you put it. The nature of our constitutional system is that Congress is the first branch and it needs to take the lead on many of these issues. So, hey, maybe we actually do need more resources. Do you find that to be a credible argument?
Humbling Congress is penny wise and pound foolish. It's kind of similar to the argument over term limits. States that have limited the terms of their legislatures have not found a correlating decrease in the size and scope or activism of government, because it turns out the lobbyists and the staffs aren't limited. You're just having more rookie, inexperienced lawmakers at the beck and call of people like us who produce model legislation or what have you. So I would actually, I think having bigger staffs to be able to do these sorts of things would be a good idea. For that matter, I think Congress itself should be bigger. There should be more congressmen. That would also solve a lot of gerrymandering issues, accountability issues, have people closer to the ground. And perhaps solve some of the dysfunction where everything is run through leaders' offices and most members. The incentive is, as one of the freshman lawmakers last time around didn't even have any policy people and threw all his resources into comms. That's not a healthy thing.
Ilya, this brings up a related question. Recently, there was a judge on the Ninth Circuit Court of Appeals, a very prestigious body, very visible and impactful body, who was appointed by President Obama, who resigned so as to take a position as a partner at an elite law firm. This is someone who is appointed in his 40s, still, very young person with a long career ahead of him. And it does seem as though there are many judges in these prominent, prestigious roles who are being appointed to the courts at earlier and earlier ages, who are finding that the material sacrifices they're making by serving on these Article III courts, are meaningful. And there has therefore been this argument that, hey, maybe we ought to increase judicial salaries. I wonder what you think about that argument, because, in the past, the common pattern was for someone to have had a long and accomplished career in private life to then serve as a judge. But, as you move towards younger and younger judges who might have to develop more and more specialized expertise, it seems not unreasonable to suggest that you might want to do something on the comp side. But I'm curious about your take.
I haven't looked at the average age of judges historically. As far as justices are concerned, that really hasn't changed over time. And you had Justice Story, who was, I think, 32 when he was appointed to the High Court. I do think that salaries of high officials need to keep pace roughly with their private sector equivalents if we want to draw good talent into those important roles. And although federal judges aren't paid poorly, I can certainly sympathize with 4 little kids and the cost of tuition that outpaces inflation, the types of material pressures on these folks. And some judges, like the one that you talked about, once it becomes clear that they're not going to make the Supreme Court, they decide, we'll just go back into the private sector and write my own ticket, as it were. The political problem is that historically judicial salaries have been tied to congressional salaries, with circuit judges tied to senators and district judges tied to congressmen. And it's a separate debate whether members of Congress are underpaid themselves, but splitting that tie, I think, would be healthy.
Would be interesting. And it also comes to mind in light of recent controversies over Supreme Court ethics. It really does seem as though there's been a sustained campaign to suggest that Supreme Court justices can't simply regulate themselves when it comes to ethical conduct, but rather that there needs to be some legislative intervention. I wonder if you could tell us a bit about this debate, some of the kind of historical factors that we ought to take into account and what you think would be a sound solution, if any.
As we're talking about this, we have to issue our disclosure because, of course, Paul Singer is the chairman of MI's board, and Harlan Crow's wife, Kathy, is also on our board. They've been implicated in these so-called scandals with Justices Alito and Thomas, respectively. They're non-scandals. I mean, someone going on a trip and even being given nice hospitality. First of all, under the rules in place at the time, which were just changed this past March, they weren't subject to disclosure, all those trips and things. But secondly, there's no evidence of a quo. It's judges and justices palling around with rich people. That is a non-story. That's happened from time immemorial. It happens by judges of both parties. Justice Ginsburg is now under investigation, or not under investigation, but the story is being discussed that she accepted $1 million prize from some organization, and she claimed that she was going to give it all away to charity. But the record of that has been redacted, and all. Look, the justices are going to write books. They're going to go on speeches. They're going to teach classes in exotic summer destinations. I don't think any of that determines how they're going to vote on major, controversies that get all the headlines, or even minor cases that are below the fold that end up being ruled on unanimously regarding bankruptcy or securities regulation or what have you. So I don't know whether the issue is we need more disclosure. I don't think it matters that much. I'm just not concerned about the ethical propriety of not recusing yourself from a case because you forgot that you had $1,000 or $10,000 of AT&T stock or something like that. And unlike other courts, when a justice recuses, there's nobody to replace them. So that's a real damage to the court in those ways. This is a concerted attack by the left, who's disappointed with a lot of the rulings of the court in recent years. On the legitimacy of the court and on their ethics. It's really a non-problem. Nobody can point to some of the corruption allegations that actually were happening in the 19th century, for example. Of course, not covered in real time on Twitter back then. But the public's confidence in the court is not driven by the latest breathless ProPublica investigation. It's largely people say, do they like what the court is doing, and can they understand what the court is doing? Other than that, this is a parlor game among elites.
Recently, one of the nation's most prominent legal academics, Mark Tushnet, urged the Biden administration to embrace what he's called popular constitutionalism. Specifically, he urged the administration to restrain MAGA justices immediately by announcing that if and when they issue rulings that are based on gravely mistaken interpretations of the Constitution that undermine our most fundamental commitments, the administration will be guided by its own constitutional interpretations. That seems like a pretty bold statement. And again, Mark Tushnet is not a crank. He is someone who is held in high regard by a great many legal scholars. So I wonder. Well,
someone could be a crank and yet held in high regard.
I'm curious to hear your thoughts on Tushnet's call to arms for the administration and for progressives writ large.
I think it's going to come back to bite him, just like his previous call to arms in October 2016, when it looked like Hillary Clinton was going to win the election and appoint the next several justices, where he called for the end of defensive crouch constitutionalism and for the left to go on the attack in terms of jurisprudence. And that didn't play out so well. I think similarly here, this really slips the mask and shows that it's all results oriented as far as, even someone like him, who's kind of a baby boomer liberal lion at Harvard Law School. And so this is a serious attack, I think, on the court. And to say that the decisions that the court is coming up with. It's one thing to say that you disagree with it, to say that they're illegitimate or deviates fundamentally from constitutional interpretation. Some of that is projection. Some of that is just being in this position that they're not used to, where we don't have the, as we discussed earlier, the swing vote that tends to move left, at least in issues of the so-called culture wars.
It is striking to consider some of the Roberts Court's most visible and consequential decisions. If you look back to Dobbs, which you'd referenced earlier on, and then looked at the Students for Fair Admissions case, these are both cases that did not obviously advance the political prospects of the political right. So in the case of Dobbs, for example, this is something that many conservatives had championed for a very long time, the idea that Roe v. Wade was wrongly decided. This was a view, in fact, held by some legal liberals as well, at least on the merits of Roe v. Wade, the way the case was argued, the way the decision was drafted. But there's certainly an argument to be made that so far, at least, Dobbs has redounded to the benefit of pro-choice Democrats politically and energizing the base. When you look at for Students for Fair Admissions, this is a case that's certainly been very controversial among progressives, and particularly progressive academics, but it's something that seems to enjoy broad support in the public, and it's not obvious that President Biden is going to campaign that the decision was wrongly decided. So I'm curious. I mean, Justice Roberts famously said when he was first going through his confirmation that he wanted to be a judge who was like an umpire, who was calling balls and strikes. When you look at the Roberts Court so far, particularly in its most recent iteration, do you think that the Chief Justice has succeeded in that regard?
Well, he hasn't succeeded in his larger institutionalist goal of extricating the court from our political debates. I think that's an impossible task. And no amount of tacking left and right and his kind of minimalistic methodology, his what he did in NFIB versus Sebelius, the Obamacare case from now 11 years ago, transmogrifying the individual mandate into a tax in order to save it. I think he's failed in that project. But in terms of calling them like he sees it, the court more broadly doing so, I think we have a clearer court now, and you can certainly disagree with it, but you know where things stand rather than kind of the inscrutability of the Kennedy years from the mid-2000s after Justice O'Connor was replaced by Justice Alito through 2018 when Kennedy left the court. Those 12, 13 years, it was like often throwing darts at a dartboard and trying to figure out what the court was going to do. Now, again, you might not like it, but it's a little more principled, I think, or at least conventionally principled in a way that can be figured out, even though there are a lot of varieties of originalism and textualism and what have you on the right.
Ilya, what about the charge that the Roberts Court has been hyperactive in overturning precedents and therefore destabilizing the law?
As a statistical matter, it's simply a false charge. Jonathan Adler recently wrote a fascinating feature piece in National Review analyzing the overturning of precedent, or for that matter, striking down laws. And on all of these metrics, the Roberts Court does less of that than the Rehnquist Court, the Berger Court, the Warren Court before it.
Ilya, thanks very much for joining us.
My pleasure, Reihan.
Listeners, don't forget to check out his work for the Manhattan Institute. We'll link to a scholar page in the podcast description. If you like what you heard on the podcast, please feel free to write a review wherever you listen, and be sure to tune in to future episodes of Manhattan Insights. I'm your host, Reihan Salam.